Well, hi there. This is another day in the life of a small business employment attorney video. My name is Scott Shibayama. I'm the founder of Vision Law Corporation. Now, here's a topic that may seem kind of esoteric, but it's going to be coming up more and more often with the baby boomers aging. And more folks having a need for caregivers. So this is going to be about wage and hour law, California wage and hour law, overtime and double time, but specifically in the context of a residential care facility for the mentally disabled. It can also be applied to residential care facilities of the elderly, RFCE for short, and caregivers. So some background facts. I have a client, and this happened yesterday. We had a DLSC settlement conference, but first the background for how we even got there. Client has 4 residential homes for the mentally disabled, and has, I think she said, 8 employees total. So a small employer. Hired this particular caregiver, was there from about March 2020 through April 2022. So roughly 2 years-ish. The person's schedule, or they claim their schedule was 3 days in a row. Basically, think of starting at, say, Sunday, 6 o'clock in the evening, and they stayed over. They, quote, lived in, if you will, but they stayed overnight. Sunday, worked Monday, stayed overnight Monday, worked Tuesday, stayed overnight Tuesday, and left on Wednesday, say 5 p.m. So it's several days in a row, and as many of you may be guessing, presents some potential overtime issues, not only overtime issues, but double time issues as well under California law. What happened? The employee separated. I believe it doesn't matter how she separated, but she separated. Then turned around and sued the employer before the California Labor Commissioner's Office, Division of Labor Standards Enforcement, DLSE for short. For what? For a wage claim, for failure to pay overtime, failure to pay double time. And I should have said this. So my client had the worker keep track of all of her time. So her hours worked. She clocked in and out. And my client only paid her regular, like straight time, even if this employee worked overtime or maybe even double time, which is a good time to state the California rules relating to this. Anything up to 8 hours is regular time, so straight time in a workday. Anything over 8 hours, up to 12 in the same workday, is overtime. Overtime is 1.5 the regular rate of pay. Anything over 12 in a workday is double time. So this employee's argument was that she worked 24/7 between Sunday evening and Wednesday evening, and that she should have been paid for all of the hours. So you have some 24-hour blocks in there, right? And so if you think about that, even at minimum wage, which this employee was at, but take a minimum wage of $14 an hour, if anything, if we're counting all 24 hours in the workday, which is a 24-hour period that's necessary to calculate California overtime, then she gets paid $14 an hour for the first 8 hours. She gets paid 1.5 times that for the next 4 hours. And then she gets paid double, or $28 an hour, for anything over 12, which would be another 12 hours. And as one might guess, that can become a very large daily wage. And by the way, so workday is a 24-hour period of time, and we have to define a work week because California also applies overtime to anything over 40 hours in a work week. But in this case, that 40-hour work week test doesn't matter because the daily overtime was far in excess of any weekly overtime. And so you define a 12-hour period of time, which we defined as 12 a.m., the start of a new day, all the way through 24 hours later. And the workday started on Sunday and ended on Saturday, following Saturday. So the complaint, I'm looking at it. So she filed the complaint. We got set for the usual conference. And so before the Labor Commissioner's Office for wage claims, there's a two-step process. The first is a conference, which is essentially a settlement conference. And if the case does not settle at the settlement conference, then it goes on for a hearing. And like I tell all my small business clients, unless they have like a really good defensible position, you're going to want to settle the case for as close to zero as possible, of course, but you want to settle at the conference, the settlement conference. You do not want to go to a hearing because there's a lot of risk to go to hearing. And the outcome also is dependent on which administrative law judge you get. A lot of them are great, so I've had great ones. I've also had some that I felt were quite biased against the employer, but that was the rare event in actuality. And by the way, I only get involved in hearings if I feel like we can win the case. So anyway, we're not at a hearing yet. I advised this client, I crunched some numbers, I took a look at this person's time records, and back to the complaint. So she's claiming, or was claiming, 2,540 hours of overtime. So the premium component, which is on $14 is $7, right? 50% premium. Why? Because my client had already paid the $14 an hour straight time. She just did not pay the premium component. So 2,540 hours times $7 an hour, and then double time, 3,810 hours at $14 an hour. So that's the premium, right? Double time. So 14 is the regular rate of pay. My client paid that, but my client, if there was double time proven, would owe another $14. And so that came out to roughly $72,000, I want to say. Yeah, $71,120. But on top of that, of course, in the sunny state of California, we have additional penalties if an employer does not pay all wages when they're due. And this is upon separation. If an employer terminates employment, they must provide the final paycheck immediately. I mean, literally, you're fired, here's your check. If the employee quits with less than 72 hours notice, then the employer has 72 hours to get the employee their final paycheck. If they give more than 72 hours notice, then the final paycheck is due on the last day worked. For example, somebody gives 2 weeks notice, employer allows them to work through that notice period. Their final pay would be due on that last day of work 2 weeks later forward. So how does this work in terms of alleged back pay and overtime and double time? The theory is if the employee were to win on either the overtime or double time claims and was owed any back wages, then they were owed that at the time of separation. And because the employer did not pay what was to them unknown overtime or double time due, there's the waiting time penalties. And the waiting time penalties are 1 day's wages for every day that the employer is late, up to a maximum of 30 days. So quite often in these scenarios, the employer is looking at paying the full 30-day penalty because just the timing of it, right? I mean, the employee separates, either quits or gets fired. Employer does not receive a claim until well after 30 days once the employee's gone. And so the complaint comes in, let's say 6 months later, alleging overtime or double time. And I have to tell my employer clients that if we lose, we get to pay 30 days wages as a penalty on top of whatever is found to be due. All right. So in this case, it was like $16,000 because the person was claiming all this overtime and double time every day she worked. So basically she was claiming 24-hour pay periods, which were not compensated, for overtime, 4 hours in that 24-hour period, and 12 hours for double time in that same 24-hour period. So when I crunched the math and looked at her time records, unfortunately, she clocked out, and the schedule was such that, contrary to what she was saying, she did not actually work 24 hours consecutive. Or even on days that she did, you split the time. So for example, if she clocked in at like 7 o'clock p.m. and worked all the way through to the next morning, 7 a.m., that would be 12 hours of working time, right? But because, and you know, she's saying that that would be overtime, 4 hours of overtime. But when you look at the work day, which is how we calculate overtime, 7 p.m. to 12 a.m. is on one work day, and that's 5 hours work. And then 12 a.m. to 7 a.m. is worked on the second work day, which is 7 hours work. So whereas she's counting that as overtime, there is no overtime in reality, simply because of the way daily overtime is calculated under California law. So parsing all of her detailed time records, roughing it out real quick. This didn't take me very long for 2 years worth of time, but you know, no spreadsheets involved, just down and dirty, handwritten, looking at the time records and just calculating, you know, how many hours worked in a work day, a 24-hour period. Once I got those numbers, and there were some days where she worked 24 hours in the workday. There was some time when she worked 24 hours in a workday. And in that case, she was in fact due 4 hours of overtime and 12 hours of double time. So there were instances that was the case, just not 100% of the time, such that she was getting these thousands of hours of overtime and double time work. So in the story, I come up with hours, and I think I came up with about 800 hours of overtime versus her 2,540. I came up with about 463 hours of double time versus her 3,810 hours of overtime. And so obviously that $7,100 overtime double time claim was reduced to still some significant money, but not out of control, right? So it came out to be about, I think, just under $11,000 at $14 an hour, calculating the 800 or so hours of overtime and the 470 or so hours of double time. And then based on my calculations of her average daily rate, the waiting time penalties came out more like 6,700 or thereabouts. So total real exposure, honest exposure, right? Calculating what legitimately was due to her, because my client paid straight time only and not overtime or double time on the hours worked, came out about 16,500 or so, 16,500. So going into the settlement conference, of course, I advised my client that was the case. You know, they were very surprised to find out that this is how it worked. You know, and this client had been in business, or has been in business, for 25 years, running these residential care facilities for the mentally disabled, has 4 houses, 8 employees, being treated the same way in terms of their hours worked. So you can see where this is going. You know, she's owing potentially 16,500 or so for just one employee, but could have been the case for her other 8. So if you're multiplying 16,000 times 8, that becomes a much larger number. So of course I have to talk to this employee about how we're going to fix things going forward. And I'll tell you all listening in what the advice is by the end of this video. But getting back to the conference yesterday. So we have this conference before the DLSE. We have a Deputy Labor Commissioner out of San Bernardino County, playing mediator or settlement conference judge, if you will. And after a bunch, this is a rather lengthy conference, probably about an hour and a half. We finally got her down from her $88,000 claim with a bunch of back and forth. And we ended up at $25,000 with a 4-month payment plan. So roughly $6,000-ish a month, payable over the next 4 months. And, you know, I told the client going in that, you know, if we had to pay even up to about $30,000, it'd probably be a good result, because we definitely have a problem to the tune of around $16,500. But then you've got your own attorney's fees for us to represent you at a hearing. And plus there's risk at the hearing. The hearing judge may not see it the way we see it, even though I feel confident that based on our time records and the evidence we would present, that my numbers were pretty accurate. But nevertheless, you never know. Anything can happen in a labor commissioner's hearing, and we could have got hammered, for $60,000. I mean, if she was believed, 71,000 is not out of the question. If you're counting every day you work 24 hours a day, according to her, then it could be a very big number. And so we ended up settling for that $25,000 with a 4-month payment plan. And the client, believe it or not, was very happy with the result. And of course, we're having sidebar conversations throughout the settlement conference to make sure that she's comfortable with where things were ending up. So that was yesterday. Got the case settled, client happy. But what does she do going forward? Really the advice is that, hey, you have your employees clock in and out, and carve out 8 hours of sleep time, so long as it's uninterrupted, because under California Wage Order 5, there's special overtime, double time rules, or at least special hours work rules, where an employer that's a residential care facility for the mentally disabled, the elderly, or for underage, for minors, right? In rehabilitation, you only get paid as a caregiver for the actual hours worked. And if you're sleeping, those are not counted as actual hours worked. But believe it or not, and you need to have this in writing, and believe it or not, if you don't have it in writing, and or you don't have any time clock records, then this 24 hours worked argument can absolutely fly, and it can absolutely be a very big number. So for you residential care facility employers out there, you want to have folks keep track, and this goes for anyone, actually any employer, any industry. You should have all of your non-exempt employees keep track of every second they work. And I mean it, under the developing case law, you should record time to the second, at the very least the nearest minute, and pay to the nearest minute or to the exact second. And that's absolutely critical to defend any sort of wage claim. It starts with the time records. And of course, the time records have to flow through to the payroll records of the pay stub. And we need to do the math correctly and have all regular hours worked, all overtime hours worked, and all double time hours worked, if appropriate, listed separately on the pay stub as separate line items, with the hours worked times the appropriate regular rate, overtime rate, or double time rate. So that would be that's my advice to her. Put it in writing. She also told me there's plenty times during the day where the caregivers are not working at all because all of the residents are out on a field trip or out somewhere else. So there's nobody to watch over. And so under those circumstances, that also should be clocked out as non-working time, because they're not doing anything. They should be off the clock. And when you do that, then you're going to, one, be able to prove the exact hours worked, be able to carve out legitimately sleep time, so long as it's not interrupted. And by the way, if sleep time is interrupted, then that does count as hours worked. And unfortunately, if the caregiver does not get at least 5 hours of consecutive sleep time, then it does convert all of those 8 hours that we want to be called sleep time, converts it into working time. So that's not a good result. But in any event, that's the best way for a residential care facility to reduce potential overtime and double time liability. We'll have other videos that talk about other wage and hour type claims for the normal situation, because this is a unique industry. But we'll have opportunity to talk about how it applies to a doctor's office, a car dealership, a restaurant, whatever. So we'll sign out for now. Again, my name is Scott Shibayama. You can learn more if you like at visionlaw.com. Aloha for now.